Now we are not talking about lists. Now we are not talking about lists. We're talking about preamble. We're talking about 356. We are talking about fundamental rights. Each of those orders require the concurrence of the state. I'll show that to your lordship.
The power of Parliament to enact law is under 245 and 246.
246 will not apply.
No, but the power is somewhere else apart from B.
No, I'll come.
B recognizes the power of Parliament to enact a law because it says the power of Parliament to make laws for the state shall be limited. It's a limitation.
No, it's a limitation.
But Justice Paul also says that it's a limiting clause.
Yes, quay that list only means quay that list.
So if it were a limiting clause, the power of Parliament to enact the law is traceable elsewhere.
No, now,
can we say that 370B gives power to Parliament to enact law? No. It limits the power of Parliament to enact law to a certain extent.
I was trying to explain what
yes.
Lord put to me. Please allow me. But
yes.
What I was trying to say was that here, what the clause says is that quay the lists in the instrument of accession, right? Parliament may make a law, but that will be in consultation.
It's a double limitation, Mr. Sabal. See, the first limitation is the Chief mentioned. The power of Parliament to make laws for the state shall be limited to.
Yes.
What is it limited to? To matters in the union list and concurrent list. So, first part is matters in union and concurrent.
Correct.
But second qualification, which in consultation with the government of state, there also you are right, to that extent you are right, it is in consultation with government of state, are declared by President to correspond to matters specified in the instrument of accession.
Correct.
Governing the accession of the state.
Correct.
So such parts of union list and concurrent list, which form a part of the instrument of accession, because everything else doesn't form a part of the instrument of accession. The whole list doesn't.
Right.
To that extent, Parliament can enact law. Parliament is limited to enacting laws in respect thereof in consultation with the government.
Absolutely.
That's how
that's what I'm saying too. But they are not, at that moment, the law is not made. They are only saying the contours under which Parliament will enact a law. The contours with respect to instrument of accession are those four items: communications, defense, external affairs, and ancillary, which I showed to your lordship the schedule. When it comes to B2, the contours again of the items in the concurrent list over Parliament may make laws. Again, it doesn't say that law is made. It only delineates the contours. Therefore, I'm going to now distinguish it from D, Malad. That's how I'm trying.
Let's come to D. How would you?
I'm just coming.
Yeah.
Then you come to see the provisions of 1 and of this article shall apply in relation to that state. That's not covered. That's not covered.
Right.
So that's Malad's 1 is integration into India. And Malad's, the other is Article 370. Now come to D. Such of the other provisions of this constitution. Now we are not talking about lists. Now we are not talking about lists. We're talking about preamble. We're talking about 356. We are talking about fundamental rights. Each of those orders require the concurrence of the state. I'll show that to your lordship. Here it is such of the other provisions of this constitution. 371B doesn't talk of any other provisions of this constitution. It talks of the instrument of accession and the concurrent list, the contours of the power. When you come to other provisions of the constitution, these may be made applicable. That's why the order. Now let's read it further. Such of the other provisions of this constitution shall apply in relation to the state, subject to such exceptions and modifications as the president may order set specify, not referred to 371B. There's no order, no question of order there. It's only the contour of the power. Now read. Provided that no such order, that is, no such order relating to D, which means provisions of the Constitution of India to apply to Jammu and Kashmir. No such order which relates to matters specified in the instrument of accession referred to in paragraph 1 of clause shall be issued. Kindly note the word issued. That's the difference between 371B and 371D. Because no orders are issued under 371B.
That's the power to make law.
That's only the contour of the power. Your Lordship asked me the difference between the two. I'm just trying to advance an argument with respect to the difference. It's entirely different.
Yes, much.
So, Attorney General, that too, constitutional practice is one thing. We are now looking at just the text of the provision. There are two possible constructions of clause D. Constitutional practice may seem to support what Mr. Sibal is saying. One is that D refers to the fact that other provisions of the Constitution may apply such
Other than 1 and
other than 1 and 2.
1 and
Such of the other provisions of this Constitution shall apply in relation to that state, subject to such exceptions and modifications as the President may by order specify. In other words, if you are making exceptions or modifications, that's one construction. That if the President is making exceptions or modifications, then if it relates to a B1 subject, then you require consultation with the state. If it relates to something other than a B1 subject, you require consultation of concurrence of the state. All right? So it is only where you are making exceptions or modifications in the Constitution that it requires either consultation or concurrence. The other interpretation is that even if you are not making any exception or modification, but you are making some provision of the Constitution applicable to the state of Jammu and Kashmir, you still require either consultation or concurrence, even if you are just bodily lifting it and making it applicable without exception or modification. That's the second construction of D.
That's correct.
Now, the question is really which is the more plausible construction?
I come to that. But actually, if your Lordship looks at the 1950 order itself, it will give an indication of what was meant. And just not leave 54.
That's why, Mr. Sibal, the Chief Justice, the constitutional practice does support this view, but there are two plausible constructions which can be made. One is that the entire Constitution has been adopted in terms of clause D. If you require modification or changes in that part, then you require a presidential order which shall be issued in consultation, not in consultation, with concurrence of the state.
I appreciate that, but that will render 3 OCOs completely. C will become OCOs.
C is
the provisions of the Constitution.
The C is something different. C dilutes the article itself.
C, Madhaj, I am not on anything else. When you see other provisions of the Constitution, except for 1 and the 370, you can't touch 370. But let's move forward, Madhaj. I'll be able to show that to your Lords.
P is 370 and C is Article 1.
And 1 is Madhaj integration. So that can't be touched. If it's part of India, can't be touched. 370 can't be touched. All other things can be touched.
It doesn't say, C doesn't say it cannot be touched.
Interpretation.
C doesn't say 370 cannot be touched. In fact, clause 3 makes it very clear it can be touched. Just say that.
By now, your Lordships have, in fact, Madhaj, may I tell your Lordship something interesting? Because I looked at the original Constitution of India. The friend will show it to your Lordship. It was only a marginal note. It's not the heading of 370.
It's a marginal note, absolutely. No doubt about it. It's a marginal note.
It's a marginal note. And your Lordships have held in Keshavanam Bharti itself. Can't look at these notes.
No, in the sense that a marginal note doesn't control the meaning of the text.
C and 3, Article 3. You can't. A marginal note can't say it is temporary, therefore I read this in this fashion. Can't be done. Anyway, come to that one. Let me Madhaj, show you. It's
Yes,
very
yes,
fascinating.
yes.
But I take a bit of time. Let's kindly come to 370 presidential order.
That 1954 order.
1950.
Let's have a look.
50. Same volumes.
1950 or 54?
No, Madhaj, I'm coming to 50, Madhaj. Liquid text. Volume 3, PDS, page 4, Madhaj.
This is what you were reading as 13. No,
No,
something.
that is the 54 order. I'm coming back to 1950 order, which was superseded by the 54 order.
This is where?
This is PDF 4 in the same volume. The other was on at 13, this is at 4.
So that's 4.
Yeah.